Vicky asked me, would I do something on promissory estoppel? That was last week. I got a bit busy, so it's Sunday evening now. I thought I'd get down to it. When one talks about promissory estoppel, the first case most people deal with is the High Trees case in 1947. But we need to look at an earlier case. However, we'll deal first with the High Trees case. In this case, a block of flats had been let out, and the person who took the lease was going to let all the flats out individually. Unfortunately, the Second World War started, and it was hard to get tenants for the flats. So the landlord made a written agreement or written promise with the tenant that he could pay half rent. Now, in the last 2 quarters of 1945, the flats were fully let. The question was, could the landlord now get his full rent for the future? And could he also get full rent for the last 2 quarters of 1945 when the property was fully let? And the court decided that he could. Now, when a court makes a decision, that decision is technically known as the ratio decidendi, or the reason for the decision. Sometimes the judges go on to talk about other matters connected with it, which are not part of the decision, and that's known as obiter dicta. And that's matters spoken by the way, and that's what Lord Denning did here. He asked the question, what if the landlord had tried to go right back to the beginning of the lease in 1939 and collect, when it was difficult to get tenants, and collect the arrears of rent? And he said he would have been stopped in equity from doing that. And he relied on lots of cases, but one particular case we'll deal with now is Hughes against the Metropolitan Railway Company, a case concerning the lease of some buildings at what is now Euston Station. And there was a covenant in that the person who took the lease had to carry out repairs when they were asked to do so. And the term provided it must be done within 6 months. So that notice was given to repair. A month passed, and then the parties entered into negotiations for the sale of the lease. What happened was negotiations broke down. The landlord then brought an action for forfeiture of the lease because the 6 months was up. The court decided that during the negotiations, that 6 months period stopped running and that it must start afresh from the breakdown of negotiations so the lease wouldn't be forfeited. And Lord Denning had said that what that case was really about when he was dealing with the High Trees case was not so much about forfeiture, but about the doctrine of promissory estoppel. Now, 4 years later, that's after 1947, after the High Trees case, along comes a case called Combe and Combe. And Lord Denning deals with that case there and takes the advantage of laying out what the doctrine of promissory estoppel is. Not using his exact words, but in essence, where a person makes a promise that they will not insist upon their full legal rights, and he makes the promise with the intention that it should be acted upon, then if it is acted upon, he will be stopped or prevented from going back on that promise where it is unfair or inequitable to do so. Now, subsequent cases have laid out the requirements for promissory estoppel. There must, first of all, be an initial contract. And that contract has given the parties certain rights. And one of the parties makes a promise to give up some of their rights. And he makes it with the intention that it should be acted upon. Then if it is acted upon, he will be stopped from going back on that promise if it is unfair to do so. Also, there must be a true accord. And for what we're meant is meant by this, we can look at the case of D&C Builders against Rees. D&C Builders had done some work for Mr. and Mrs. Rees, and they sent in their invoice. Mrs. Rees discovered that the builders were struggling financially. She took advantage of that, and she offered them part payment in full satisfaction, and they agreed to that. Later on, they then sued for the balance, and she raised the doctrine of Promissory Estoppel, but it couldn't apply, and she was unsuccessful because there wasn't true accord. She had forced them to make the promise. Another way of looking at it is that there is a maxim in equity which provides he who comes to equity must come with clean hands. And so if you come to equity looking for fairness, essentially you have to act fairly. So there must be a true accord. And another requirement is that the promise must be clear and certain. And a further promise is the party must have acted upon that promise. It's not necessary that they act to their detriment, although they may do, but they must certainly have acted on the promise.